pleasant good afternoon again to everyone. My name is Priscilla Liebert-Calder. I'm the event coordinator for the NJSBDC at Rutgers-Newark. And on behalf of Dr. Tendai Ndoro, she's the regional director, I would like to welcome you to our webinar titled Legal Considerations Involving IP for Small and Startup Businesses. For those of you who may not be familiar with the SBDC, which stands for Small Business Development Center, we are the premier provider of business training and consulting services to establish small businesses and entrepreneurs here in New Jersey, more specifically those in Essex County, New Jersey. We are one of 12 centers in the NJSBDC network, each center being responsible for one or multiple counties. Our center is hosted by the Rutgers Business School and funded through a partnership agreement between the United States Small Business Administration, Rutgers University, and the New Jersey Business Action Center. Our mission is to help entrepreneurs and business owners start and grow successful, sustainable businesses. And we do this through providing one-on-one business consulting, training, and technical assistance programs. For the benefits of those who are attending today's webinar, audio has been muted for participants. And so we'll be taking questions, via the chat and the Q&A feature. So we do ask if you have a question, post it to the Q&A. That way we don't miss it in the chat. Sometimes we tend to overlook a question or two. So you can communicate in the chat, but post important questions that you need answers to the Q&A. A copy of the presentation slides will be sent out along with a video recording of this webinar. We usually send this email together, but due to the delay sometimes in getting out the recording, sometimes you receive that long after. So you may get an email that just has the slides immediately after the end of the presentation, and the video would then, the link to the video will come at a later time. Okay, so it is now my pleasure to introduce to you our presenter for today, Michael Malia. He is an IP attorney and an SBDC consultant here at the NJSBDC. So some of you, it doesn't matter if you're in Essex County or not, you may have an opportunity to either work or speak with Michael if it's something legally or something related to his expertise with us with the SBDC. So without further ado, I will turn today's presentation over to Mike.
Hi, thank you, Priscilla, and thank you for everybody who's joining. Let me share my screen. So like Priscilla was saying, I am an attorney. I'm a patent and intellectual property attorney. My practice is involved with all aspects of IP law, where IP stands for intellectual property. You know, I mainly focus with patents, trademarks, and legal opinions, but I also do a good amount of contract drafting, review, and negotiation. I've worked in small firms as well as large firms. My law degree is from Seton Hall University, where I had a concentration in IP. Before that, I earned a bachelor's degree from Rutgers School of Engineering in biochemical engineering. My practice is located in Montclair, but I'm admitted to practice in New Jersey, New York, as well as the USPTO. And for context, the USPTO is the United States Patent and Trademark Office. So I am an attorney, but I'm not your attorney. The information provided during this webinar is general in nature and is not legal advice. Nothing contained in this webinar is intended to form an attorney-client relationship, and you should seek the advice of competent legal counsel of your choosing before acting upon any of the information provided, as certain information may not be relevant to your particular situation. Okay, what we'll cover. We're going to go through a pretty brief intro of the various forms of IP and IP protections. We're also going to touch on agreements. We're going to then cover some general considerations and practical tips and guidelines that you can use when you are looking at IP in your business and how to really utilize that. So that's going to include asset building, which is acquiring the forms of IP protection, as well as risk assessment, excuse me, which is a very important aspect too. This is to make sure that whatever you're doing does not infringe somebody else's IP rights. We're also going to talk about how you can identify your own valuable IP, as well as the ways that you can identify IP protections for it. We'll end with some examples of hypothetical companies with some business plans and how IP and agreements can either be a benefit or a risk to them. Then also a little caveat at the bottom of that, IP is very dense and there is so much that we can discuss. So to make sure that we get through as much of this as possible, I may skip over some parts or some slides, but since you'll be getting a copy of these slides, you'll have that information. And I will try to get to all of your questions during our time together, but if not, you'll know that you can reach out to the SBDC with them and they'll refer you to me and we can talk then. So what is intellectual property? It's a very broad definition. It's an idea or a concept. So it can be a process, machine, article of manufacture, or composition of matter, or importantly, improvement thereof. These days, a lot of advancement in technology is an improvement over what's already been done, and that is protectable by patent. It's also a proprietary way of doing things or some confidential information that you have. It's also brand recognition or goodwill. This is protected by trademark. And it's also an original creative work or artistic expression, which is protected by copyright. Oop, too far. So going into the basics of patents, in order to get an invention patented, you need that invention to be new, non-obvious, and useful over the prior art. And prior art is everything that has come before your invention. And it's really important to note that until you have an issued patent, you do not have any patent rights in that invention. A patent application doesn't give you patent rights. A patent consists of a specification where you describe what the invention is, drawings to help depict the invention, and claims. And now claims are a really important part of the patent because they are what you use to protect how to protect your invention. And they come at the end of a patent, and they're the sentences that describe the various elements that are included in your invention. So in order to infringe a patent, your product or process must include each and every element that's listed in the claims. And we're going to touch on this a little bit more in the next slide, but that's very important to note. Now, the different types, there are two main types of patents in the US. They're called utility patents, and there's also design patents. So utility patents are normally what people think about when they talk about patents. They cover utilitarian features of an invention. There are two different applications to get involved with utility patents. One's the provisional application, which many of you have heard of. This is not a real patent application because it doesn't get examined by the USPTO. It never issues into a patent. and it doesn't provide you any patent protection, and it expires 1 year after you file, which means within that 1 year, you have to file what's called a non-provisional patent application. This does get examined by the USPTO. This can eventually issue into a patent, and the term of this is 20 years from the date of filing, or possibly less. Now, it's very important to cover design patents because they cover the ornamental features of an invention, but they're lesser known, although in recent years they have seen a resurgence, namely because of what happened with Apple's design patents and the litigation between Apple and Samsung a few years ago. In this litigation, Apple sued Samsung for copying certain design aspects of the iPhone. And here are two of Apple's design patents that were litigated. On the left, that design patent covers the rounded corners of the iPhone, as well as kind of how it has a rounded edge towards the sides. And then on the right, that design patent covers the rounded corners of the different application buttons when you open up the iPhone. Apple ended up winning over $500 million based on these design patents, among other things. So that's one of the reasons why design patents are important, and they should definitely be considered for your business if you're selling products or maybe even a service where you can depict something like this. But the term of a design patent is a little bit different. It's 14 years from the date of issuance. Now, going back to claims. This is one of the most misunderstood aspects of patent law, even among other attorneys. See, the patent right is what's known as a negative right. It doesn't allow you to make, use, or sell your patented invention. What it does is it gives you the right to stop others from making, using, or selling the patented invention. So here's an example. Very basic example. Let's say back in 1850, inventor A came up with an original recipe for chicken soup, and that included water, chicken, and onions, so A, B, and C. Inventor A went to the patent office and got a patent on original chicken soup. Then in 1855, inventor B came along and decided to throw in some vegetables. And this improved the chicken soup, made it taste much better, and went to the patent office and applied for a patent that had water, chicken, onion, and celery. So now inventor B has 4 elements in the patent, inventor A has 3. Now, can inventor B go and start selling his chicken soup? The answer would be no, because inventor A has an earlier patent with water, chicken, and onion. And what inventor B needs to do in order to sell its chicken soup is include water, chicken, and onion. So this is where the patent right really kicks in. Inventor B isn't allowed to go and sell his product just because he has a patent. He needs to make sure that he doesn't infringe anybody else's earlier patent. But on the flip side, inventor B was entitled to a patent on this because the new element, element D, celery, was a new, non-obvious, and useful improvement over the prior art, which was inventor A. So next, this brings us to freedom to operate. This is what that is known as, whether you can actually make, use, and sell your product without infringing somebody else's patent right. And like we saw, it doesn't matter if you own any patents that cover your product or process. And in order to assess your risk of infringement, you have to see what other issued patents are out there. And this is called an FTO, freedom to operate, or clearance study. It's basically you search other valid patents You analyze the claims and compare your product or process to those claims to see whether the product or process has each and every element of the patent's claim. And then there's a legal opinion on infringement or clearance. This requires a patent attorney because it is a legal determination and there's a lot of legal aspects to this analysis. But it's important to note that in a lot of circumstances, FTO, like your freedom to operate, ends up being more important than trying to patent your invention. Because if you can't sell your product, then do you really need a patent on it? But it's important to consider FTO risk in context. If you are a small business, if your revenue is small, you may not get noticed by somebody, even though you are actually infringing somebody else's patent, right? And if your revenue is too small and you still get noticed, well, maybe the patent holder doesn't think it's worthwhile to come after you. So it's important to understand your risks, but also in context. And then again, patents are territorial. So a US patent only protects you in the US. If you want to protect your invention in foreign countries or OUS, outside the US, you need to get patent protection there. There are two main ways to do this. The first is what's called the Patent Cooperation Treaty application, or a PCT application for short, or sometimes referred to as an international patent application. This is a vehicle from which you can file US and OUS patent applications. But this is not in itself something that can mature into a patent, which means that there is no such thing as a world patent or international patent. Then the other route is filing by the Paris Convention, which is basically just filing directly in any foreign country that you're interested in. And the practical point of this is that if you only have sales or market or source from one or two foreign countries, then it may be more cost effective to just file directly there. But if there's a lot of countries, maybe a PCT application is more effective. So moving on to trade secrets. A trade secret is any valuable commercial information that provides you a business advantage over competitors who don't have that information. So common examples of this are customer lists, formulas, recipes, the technical know-how around what you do and how you do it, and any internal structures that you have in place that help you do business better. In order to protect a trade secret, you need to take reasonable steps to keep that information secret. So most often, this comes in the form of marking your information as confidential or proprietary, restricting access, which means nobody outside the company should have this information unless there's a non-disclosure or confidentiality agreement in place. And it should also be restricted internally. Only the people who need to know about this information should know. Those are ways to help show that you are keeping this information secret. But there's also extreme steps to take. Like for instance, KFC and their 11 herbs and spices. So what's happened with their recipe is that the Colonel's original handwritten recipe from 1940 is still kept in a safe. And to date, there are no known copies in any format. Only a handful of employees in KFC know what the recipe is. They're all under confidentiality agreements. They're also not allowed to travel together for security purposes. And what's most extreme about this, I think, is that the actual recipe is made by two different companies, and neither of those companies know what's in the full recipe. So the way they do this is the first company mixes one half of the recipe and then sends it to the second without telling them what's in it. And the second company adds the remaining half of the herbs and spices mixes it up according to a computer program, and then ships it out. So nobody else knows what is in those 11 herbs and spices or how it's made. So moving on to trademarks. A trademark is something that indicates to a consumer the source of a particular good or service. So this is really brand recognition, because the consumer will identify you and your company as providing that particular good or service. It's important to note that trademarks have what's known as inherent strength as indicators of source. And this is denoted in this range. So on the low end is generic. Generic marks are never entitled to trademark protection. An example of this is if you wanted to use tables to sell tables. Next up are descriptive marks. These end up being pretty common because when most people are trying to select a trademark, they want to describe certain elements of their good or service. So these marks really just describe elements of, the provided good or service. An example is Windows, when it's describing Windows software. But then everything on the right, these have inherent distinctiveness. So this is what's important for a trademark, and they're known as either suggestive, and then a step above that are fanciful or arbitrary marks. So examples of this is KitchenAid for suggesting the benefit of their kitchen products. Kodak is a fanciful word. It's not a real word, so that's a strong mark. And arbitrary, so Apple for computers, because even though it's a real word, it has nothing to do with computers. So only distinctive marks can be registered on the principal register. So this is the standard route for federal trademark applications. You file onto the principal. This provides the most benefits and the most strength. So you want, if you haven't selected a mark yet, you want to try to pick something that's in the green area. Or if you have a descriptive mark, it needs to have acquired distinctiveness. And that's something we're going to talk about a little bit later. But descriptive marks can also be registered on the supplemental register. So this is a weaker form of a principal registered trademark, but it does allow you some benefits, like you can use the R in the circle mark to denote a registered trademark. And it also shows up when the USPTO or competitors or other interested parties are searching for marks, and you may be able to stop downstream confusingly similar marks from being registered. So there's value to the supplemental register. Now, another important note about trademarks is they have to be used as an indicator of source, which means they have to be used as an adjective when applied to your goods. They can't be just a name of the good itself. Not doing this properly or not enforcing against other uses or improper uses of your mark can lead to a loss of your trademark rights, which is known as genericide. So examples of this are aspirin. Bayer, way back in the day, actually had a trademark for aspirin, but there were so many other people who were using aspirin as a noun, aspirin as the good itself, that they lost trademark rights in it. Others of these are dry ice, linoleum, and even heroin. These were all registered trademarks at one point, and now they're just generic for what the good is. A helpful test to make sure that you're using your trademark properly is to say your trademark followed by the word brand and then the good or service. So for instance, Kleenex brand tissues or Apple brand computers. This makes sure that the use is going to be in the adjective form and that it's not being used in a generic manner. But the good thing about trademarks is that as long as the trademark is used properly and you're maintaining it properly, which is renewing it when the proper renewal dates come up, the trademark doesn't expire. Like, it can last forever. Okay. So US trademarks, because trademarks are also territorial. Common types. There's the federal trademark, which we've discussed, and which is really what people think about when they say, I have a trademark. This is something you apply for, and once registered, you get the right to use the R in the circle symbol, and it gives you protection across the US. But it requires that you use your mark in interstate commerce, which means your mark applied to your goods or services has to cross state lines at some point in the marketing of that good or service. So if you sell or offer services across a state line, if you advertise across state lines, which is online, you may be entitled to pass this bar. And also, if you source your goods from overseas, that's another thing that may overcome this bar, because it's a really low bar. On the other hand, there's also common law trademarks. This is just acquired by simply using your mark as a trademark. You don't need to apply for it. This allows you to use the trademark symbol, the TM in the upper right-hand corner, but these are generally weaker than federal trademark rights because it only extends as far as you're using it. Now, what can be a trademark? Basically anything, as long as it acts as an indicator of your source of goods, that is an indicator of you. So most common are word marks and or design marks. I use and or because marks can be both a word and a design. But less common aspects and also interesting ones are trade dress, like product packaging or the shape of a Coca-Cola bottle, and an interior decor. So if you've ever been inside Checkers or McDonald's, all of their restaurants look basically the same inside. That's an example of trade dress. Even smell, like Play-Doh received a registration for the smell of their Play-Doh. Color. So I'm sure many of you are familiar with Louis Vuitton's red bottom shoes or Tiffany's Robin's Egg Blue on their boxes or bags. Those are registered marks. Also sound. So the NBC chimes and various jingles like the Nationwide is on your side jingle, that's a registered trademark. And even touch. So the feel of Louis Vuitton bags and suitcases. Each of these, when you hear, feel, or smell any of these, you know who is providing those goods. So that acts as a trademark, and that's why they were able to get registrations on it. Equally important is what can't be a federal trademark. And the way this arises is that when you file a trademark application, it gets picked up by a USPTO trademark examiner who examines your application and will look for reasons why your application should not be registered. There's a number of reasons that the examiner can use. Some of the common ones are Section 2D. This is a section of the Lanham Act, which is the Trademark Act. If your mark is confusingly similar to an earlier live trademark application or registration. Confusingly similar is a legal term. It doesn't mean that there is any actual confusion. It just means that the marks are close enough that an average consumer for that good or service, when viewing the two marks, may be confused as to who's providing what, or if there's a sense that the two marks or the two goods are affiliated with each other. Like, that will be a problem. And also, it's really important to note, just because there is a dead federal application or registration, it doesn't mean that the applicant isn't still using the mark in common law. So there still may be trademark rights in that mark, just not federal ones. Another common rejection is for descriptive marks. So I have this described a little bit here. This also applies to the geographical region from which the goods do or do not emanate from. So for instance, Florida oranges as a trademark for oranges that come from Florida or don't come from Florida, that will be refused as being merely descriptive. There are several ways to overcome descriptiveness refusals. One is switching to a supplemental register. Again, we talked about that a little bit before. Another way is Section 2F. This is showing the Patent Office that you have acquired distinctiveness or you have secondary meaning in your mark. Just basically, you're telling the Patent Office, no, my mark is not descriptive of these goods or services. Consumers know that it's me who's selling them. The easiest way to do this is if you've been using your mark in commerce for the past 5 years before applying, that will allow you to file under acquired distinctiveness and overcome descriptiveness refusals. Important to note here that I have in strike through Section 2A. There used to be a prohibition on immoral, scandalous, or disparaging marks, but that was ruled unconstitutional recently by the US Supreme Court. So this case was about the Washington Redskins football team. They ended up losing their trademark rights in that. And then when they went back to the Supreme Court ruled that no, this section is improper overstep over the First Amendment. And so it's unconstitutional. And now you can register any sort of, pornographic or, cursed language, anything like that, as long as it indicates your source of goods. But whether you want to actually use that as a mark is something different, but you can if you want. Now switching over to copyright. Copyright is an original work of authorship that's been fixed in a tangible medium of expression. And it also needs to contain at least a minimal degree of creativity. And this is a very low bar, as we're going to see in a little bit. But I want to mention that original doesn't mean that it's new or novel in the patent sense. It just means it's original to you. So there are situations where two separate authors, and author here means just somebody who's created the work. So it could be a painter, it could be a sculptor, or a movie director, whatever it is. So it's possible that two separate authors create the same exact work, and both of them would have copyright rights in the work, and there would be no copyright infringement. Works of authorship are, what you would think of literary, dramatic, musical, and artistic works. But it's important to note that copyright does not protect facts or ideas. Instead, it can protect the way those facts or ideas are organized or expressed. So for instance, an organization of music, so a playlist, that may be copyrightable, even though you didn't actually make the music yourself. You wouldn't have a copyright to the music, but you have a copyright to the organization of that playlist and a compilation of facts or ideas. So an encyclopedia is just a compilation of facts, but you can get a copyright on an encyclopedia because of any of the creative choices that were used in what facts were provided or how the material was presented. But that organization or compilation can't be functional. So a phone book is not protected by copyright. And that was actually a Supreme Court case from the early 90s. Somebody who owned copyright to a phone book tried to sue somebody else. And the Supreme Court said, no, it needs to be at least minimally creative. And that's where we get the minimal degree of creativity. So what is the copyright? This is actually referred to as a bundle of rights because it's these 5 separate rights. It's the right to reproduce, the right to prepare derivative works. So if you want to make a satire or a sequel, something like that, that's a derivative work. It's also the right to distribute copies, the right to perform, and the right to display. Each of these can be separated from each other. So if you're going to license parts of your copyright, you can do that. And also you can infringe different rights within the copyright. So you may infringe the right to reproduce, but not distributing copies if you've reproduced a copyrighted work, but you haven't sold it. So acquiring copyright protection. This is very easy. Copyright attaches to a work as soon as it is fixed in a tangible medium. There's no application or registration that's needed. So once you create a work, you own the copyright to it. However, prior to enforcing that copyright in court, it needs to be registered with the Copyright Office. And there's also some additional benefits of registering a work, like you'll get increased damages in court, and you can also go to the U.S. Customs and Border Patrol and register your work there, and they'll keep an eye out for infringing works and stop it at the border. Now, typically, the author of the work automatically owns the copyright, but there are exceptions. And one main exception is the work made for hire. And we're going to talk about that in a little bit. But copyrights last for standard works is life of the author plus 70 years, which means that once the author of the work passes away, that author's estate owns that work for owns the copyright to that work for another 70 years. And also for works made for hire and anonymous or pseudonymous works, the duration is 95 years from publication or 120 years from creation, whichever is shorter. Works made for hire. Instead of the author automatically owning the work, it's the entity that hired that author to create the work will automatically own the rights. So this is important if you're, a designer, developer, content creator, anything like that. Or on the flip side, if you're a business that needs to use one of these, say you go to a web developer to create a website for you, this will come into play. There are 2 ways that the work made for hire exception comes into play. One is if it is created by an employee, and note that employees in quotes because this can also be an independent contractor, depending on the relationship with the employer, so long as that work is created within the scope of his or her employment. So that's if you have an employee, if you're an employer with an employee who created an artistic work, you would have the copyright to it. Other situations though, in the second one, it only applies to certain types of works, but if the work is specially ordered or commissioned, and this is very important, the parties expressly agree in a signed written document that the work is intended to be treated as a work made for hire. So these words have to be in the agreement. The courts are very clear on this because there is a very strong presumption in all cases that the author of a work owns the copyright to it. So if you are a business who has contracted with a web developer to create your website, you should make sure you have this language in there. And this is important on both sides. So always watch out for this. So fair use, this is a limitation on copyright rights, is whether your or somebody else's unauthorized use of the copyrighted information is okay. I'm not going to spend too much time on this because if you have concerns, you should review these factors and apply it to your situation because it's very fact specific. And you can also talk to an attorney to get some guidance on this too. So agreements. This is very important in business just in general, and also for IP, even though it's not a specific form of IP protection. Now, every agreement needs to be tailored to either your business and the specific transaction that the contract is about. So stock or template agreements, they're not that great because they just can't possibly cover every situation or particular issue. But you can start with a stock or template agreement and then revise it as necessary to make sure it meets your needs. So NDAs or CDAs, your non-disclosure or confidential information agreements, these relate to any sharing of confidential information, and they should be signed before you ever disclose any of the confidential information. And what's really important to note with these agreements is what is the definition of the confidential information, because there may be conflict between the parties about what confidential information is or isn't, and this is not something you want. Also important are what are the obligations of either or both party as to the confidential information, because NDAs can go one way or both ways, so both parties would have obligations. And then what is the duration of those obligations? So for instance, if there's an NDA that you enter into that the term is 20 years, you're going to need to make sure that that information is kept confidential for that entire period. Otherwise, you risk breach of contract issues. Next, important for our IP are licensing agreements. There are two forms. There's in-licensing and out-licensing. So in-licensing is when you license somebody else's IP to be used in your business. Out-licensing, this is when you own the IP and you're licensing it to somebody else for them to use. And this is one of the ways you monetize your IP, because normally you license your IP in exchange for some form of payment. But it's very important to note that each form of IP requires different language within the agreement, and it has different caveats and things like that. So it's important to really consult with an attorney if you're at this stage. And just in general, in many agreements, the ownership of IP or assignment language is critically important. And this should be thought of whenever something is being made, developed, created, or if there's even a chance that it will. So for instance, if you have an agreement with your manufacturer, you should have assignment language in there, because if the manufacturer, during making your product, comes up with a better way of doing it or a better detail of it, you should own the rights to that. It's very important as a business to own all of your IP. There are some examples of other agreements where this comes up. Employment agreements, very important. You can have a situation where an employee comes up with some form of IP, and if there's no assignment language, and if the relationship is a certain type, then that employee may own the rights to that. And you don't want that to happen. And also, this happens a lot whenever there's confidential proprietary information being exchanged. And in all cases, if copyright may be an issue, which often copyright protection arises, use or avoid the work made for hire language as necessary. Okay, so that's the basics. Now we're going to get into some more practical tips, guidelines, considerations, and all of that. We're going to talk about asset building and risk assessment, the due diligence efforts, the parts of this that you can do yourself and what should really be done by an attorney. And also, because this can be difficult, finding and working with an attorney. And then finally, ways that you can identify your own valuable IP and how you can protect it. So general DIY. Learn as much as you can about the topic before taking action. Yes, this sounds very obvious, and I'm sure you all know this, but it's very important in IP, and especially certain aspects of IP like patents and to a lesser extent trademarks, because even innocent mistakes in the beginning when you're first starting out may have significant impact on your IP rights. So for patents, if you do something wrong, there's a chance that you will never be able to get patent protection on that invention, either in the US or outside the US ever. So that's why it's very important to do your research first. Good places to start are the USPTO and the Copyright Office. Both of those, specifically the USPTO, that covers patents and trademarks, and it gives you guidelines, resources, videos of how to go through each process, like applying for a trademark or applying for a patent, and just the basics around it. The Copyright Office has published what are known as circulars. This also has a ton of information because there's like 60 or 70 of them, all on discrete topics of copyright law, and they're very helpful. So start there. If you have any specific questions about patent examination, that process, or the trademark examining process, the USPTO has what's known as the Manual of Patent Examining Procedure, the MPEP, and also the Trademark Manual of Examining Procedure, which the TMEP. They both have the same things, and it covers like the legal aspects of the examination process. Also, helpful sources are lawyer or law firm posts and articles online. They normally give you a lot of good information about whatever the topic is, but you should just be careful about the date that these articles have been published because the law changes all the time. So make sure you have that in mind. But try to avoid legal tech companies and other non-lawyer websites and their articles as much as possible, because a lot of the time they're not lawyers. So they're not held to the same standards that lawyers are. And the information can be wrong or incomplete, services hit or miss. And this can be very dangerous to your business because, again, mistakes can have very long-term effects. And just as a general consideration, if you're losing more than you're gaining by doing it yourself, then you're doing too much. So, next. Patents. Now, on the asset building side, it's very important to note, well, patents in general are very expensive, especially on the asset building side. So utility patents, the total cost to get a patent issued can be anywhere from, say, $10,000 to $25,000 or more. The drafting and filing of a patent application itself can be $6,000 to over $10,000. And it also takes significant time to mature. So a patent application right now at the USPTO, its average pendency is about 3 years. So the question is it worth it to patent? And this is a very significant business decision. Like, what's the potential? You should ask yourself, what is the potential value of securing patent protection? You know, what are you going to do with it? Do you have a relevant commercial market that you'll protect, and like that'll be a value add to your business? Are you trying to stop potential infringers at the source? And maybe if you're new to market and this is a brand new market with your product or service, maybe you want to scare off competitors. So having a patent can help you do that. But make sure that it doesn't end up being just a very fancy and expensive wall hanging, because that is just not a good use of business resources. Also important in this consideration is what are your chances of actually getting a patent on your invention? And this requires, and you should do in all situations, a patentability study on your invention. So this is, you go through, you look at whether your invention's been done before. One of the main reasons why you should have an idea about this is because in order to get a patent, you have to tell the public exactly what you're doing with your invention. So once you do that, you can no longer keep that as a trade secret because trade secret needs to be protected. So it's very important to do this due diligence up front. And also, on another patent topic, consider design patents. They are less expensive and take less time in the patent office than utility patents. And they can also provide strong protections like Apple's design patents. So the overall question, once you've done this analysis, is, should you keep this invention as a trade secret instead? And we'll talk about that a little bit more in the next slide. But then risk assessment. So this is whether or not you're infringing somebody else's patents. It's your freedom to operate. These can be expensive, but context is important. So if you're a smaller company with not so much revenue, it's less of a concern. But if your exit strategy in the future involves being acquired by a large company, this is pretty important for you because a larger company means larger revenue, and they're going to be much more concerned about FTO risks. So trade secret or patent. What's really important, just decide beforehand based on your use from your analysis from the last slide. Here are some more considerations. There are instances where you can use both patents and trademarks to protect your one invention, and you need to consult an experienced patent attorney in order to figure that out. What you can do yourself. So as I mentioned a bunch, you need a patent attorney for a lot of this, but some of the initial searching you can do yourself. So you can do the patentability searching. You would start with a basic Google patent search to see if it's out there. If not, the USPTO and Google Patents have expansive databases that you can search. There's also eSpaceNet and WIPO, which is Europe and the World Intellectual Property Organization. They have more databases, and they're also more geared towards OUS patents. So for patentability, all of that is relevant. You may want to check there too. And while you're doing the searching, make sure you go to the search help portions of these because that will help you craft much stronger search strings that'll get you to what you need to see much easier. And just because you didn't find it doesn't mean it doesn't exist. If you do decide to pursue patent protection, draft a brain dump invention disclosure. So what this is you draft up all of the different details and permutations that you can think about your invention, include as much as possible, make it as coherent as possible, and you would give that to the patent attorney to kind of touch up. And the idea is that the more you do, the less the patent attorney does. And for risk assessment, you can look at competing products, competing companies, see if any of those products are covered by a patent. And if so, then talk to your patent attorney to assess that risk. Now, trademarks considerations. Think about inherent strength. Don't use generic marks. Supplemental register, there are still benefits. So also consider how similar your mark is to others. And this is your main risk assessment question. We'll cover this a little more in the next slide. Important for trademarks is what's the possibility of you attracting unwanted attention from competitors? So once you file your trademark application, if it gets through a USPTO examination, it gets published for opposition, which means for the next month or after it's published in the USPTO's official gazette, and competitors and interested parties view this gazette, will see your publication, and they have a chance to oppose your mark. And an opposition is kind of similar to a litigation. And if that happens, you should definitely consult an attorney. So due diligence and filing with a trademark. The trademark search, that's what you use to assess all of your risk. There's availability, like what's the risk to you actually getting a federal registration on your mark. Clearance, this is, are you going to be infringing somebody else's mark? When do you want to do this search? The best time is before you choose a mark. This allows you to choose several different marks, search them all, and then choose which one of those provides the most commercial value based on the risks. But also, if you've already been using a mark or have a mark registered, a clearance search still helps you identify ongoing risks of your use. And when to file, this is a business decision. You've got to weigh the cost of it versus the value to the business. The costs are also not just the initial filing costs, but potential prosecution costs. That's if the patent office gives you some pushback. And also enforcement costs. So you don't want your mark to become generic, so you need to police your mark. Again, recommended to find IP counsel, but you can do it yourself as long as you research enough with the USPTO's resources. Copyright tips. So attorneys don't really get involved in the creation of copyrights. Attorneys are involved when licensing of a copyright happens or a copyright is being litigated. So there's not very much that I can add. So there's that. Finding the right attorney. So if you have a patent issue, you need to find a patent attorney. They have a scientific background and they've passed the patent bar. And you want to find one with the same technical background and experience as your technology. So if you're in the IT space, you don't want a patent attorney who does chemical patents. For the other areas of IP, just make sure the attorney has the necessary experience. The best place to start for finding one is your own network. Ask the SBDC, ask colleagues, business owners, maybe even previous employers. But what's important here is that you get referred to an attorney, because that carries a little aspect of vetting and trust and all of that. So that's really what you want to do when you're finding an attorney. You don't want to use the lawyer referral websites, because they charge a fee for an attorney listing themselves there, or for the website suggesting an attorney, and they may not be vetting that attorney. Then if you have multiple options, shop around. Cost, that's a factor, but there's also experience, competence, professionalism, everything like that, because the old adage, you get what you pay for, is sometimes accurate for attorneys. So moving on, how to work with one. You want to bring up your issues early. If an issue arises early, there may be more options available, and a good attorney will have some business sense and be able to advise you in a non-legal capacity, possibly, to avoid or at least reduce the risk of that issue occurring. When you actually find and retain an attorney, you want to discuss all options, the pros and cons, possible outcomes, effects, and costs of all of this. Basically, you want to understand what the attorney is going to be doing for you and why they're going to be doing it. As the client, you set the course. So it doesn't mean that you need to know every legal nuance, but you have to understand what the attorney is doing. This also allows you to set reasonable expectations for the project. And of course, the law is the law. There's only so much an attorney can do. For cost, if it's a concern, bring up what's known as an alternative fee arrangement. So it could be basically anything, maybe a payment plan, maybe a portion of the business is exchanged for equity. It can be anything, really. And if you're working with a smaller solo attorney, they may be more amenable to this. And the tough one, delegate and don't overmanage. This just slows down the process and increases cost. But of course, if you think the attorney is being unreasonable, like they're too slow to respond or taking too long, then have a discussion with them. Finally, also important, review bills. You should not be surprised when you get a bill from an attorney. It also helps to remember that an attorney's income comes directly from their time. So if their time is spent working with you, it's not spent working with somebody else. Now, asset building. This is important. In order to identify your IP, you want to really ask what generates your revenue and what your special sauce is. So it could be quality, uniqueness, relationships, whatever it is. Once you've identified that, you want to go through the different forms of IP protection we discussed. And for each of those, you want to ask these following questions. What's the potential value? What's the chances of getting it? What are the costs associated with obtaining it, including downstream and enforcement costs? And what are the downsides of obtaining it, like unwanted intention, or if you're filing for a patent, telling competitors what you're doing. Then, once you have done this analysis, you should have determined your best form of IP protection, pursue that first. But the real value of asset building is layering IP protection. These days, it's very rare that your IP can only be covered by one form of IP protection. So here are some instances of various IP protections that come to mind for each of the considerations we discussed in the previous slide. You want to create a comprehensive IP strategy for your business. And you do this by iterating that process from the previous slide. So once you've identified your most valuable IP, then you go to the next most valuable IP and repeat the process. As you continue doing this, you're going to get to a point where the costs and the downsides outweigh the value. And that's when you know you have a pretty reasonable, comprehensive IP strategy. And even for those aspects of IP that you're not going to protect, if there's a low risk of to your use of that IP, then you can keep using it, just you're not going to take any steps to protect it. That's perfectly fine. So Hypo 1, ABC Co. ABC Co sells widgets in the US and Canada. These widgets are being sold by other companies, but ABC Co has recently created a new widget design that is a significant quality improvement over competitors' widgets and wants to bring it to market. So what can ABC Co do before entering the market to protect its business? So here are the various things we've discussed. Patents. What should they do? First, maybe a patentability search on the new design to see if it could be patentable and they can protect it. Also, when they're doing this, they should identify what the potential market is for this new widget to see if it justifies getting a patent. Also, design patents. If they can create an ornamental design for this widget that's not functional in nature, that can be protected by a design patent. On the risk side, they should conduct an FDO risk to the extent that it makes sense to the business to make sure that they're not going to be infringing somebody else's patents. Trade secret, this correlates to the patent question. If it's a low chance or it doesn't make business sense to apply for a patent, then definitely keep that information as a trade secret. Trademark, this will definitely come up. In this case, because it's a new widget and it's a quality improvement, it would probably make the most sense to create a new brand for this product. So this would be a time to select multiple trademarks and conduct your searches to see which one would be best for your company. And also remember, for trademarks and for patents, you need to duplicate this effort in the US and in Canada because they're territorial. Copyright, so this is less so important for ABC Co. They'll have copyright protection in any of the marketing that they're going to use with this new widget, also in artistic aspects of the product packaging and things like that, but this isn't going to be like a main value driver of this product. An agreement. So this is very important. First, they would need to look at the manufacturing agreements and maybe distribution agreements to see if this new product will be covered. Also particularly important for the manufacturing agreement is what's the confidential information? Do they need to sign a new NDA or CDA in order to cover this information? Or will it also be covered with whatever confidentiality agreements they have in place? And just in general, they should enter into an NDA before contacting the manufacturer if it's not covered. So Hypo 2, DEFCO. DEFCO provides disc jockey services for weddings throughout the northern New Jersey area under the name Bridal Party Music. DEFCO has been in business with the same name for the past 10 years, but now DEFCO is considering expanding its wedding DJ services into New York and Pennsylvania. And at the same time, DEFCO wants to start selling recordings of its playlists through an online store. So what issues is DEFCO facing here? So for patents, probably not much. All of this has been done for years, so there's probably nothing new or novel. And on the risk side, because it's been done for years, it's unlikely that there's a patent owner that still has an enforceable patent on any of this. Trade secret, also not so much. Maybe DEFCO has some particular way of organizing its playlists that's unique to DEFCO. That may be a trade secret, but otherwise there's not too much. Trademark, this is important. So DEFCO has common law rights in bridal party music in the northern New Jersey area. Now, if DEFCO wants to file a federal trademark application, that may be, it'll depend, because bridal party music, will that be considered descriptive or generic of the services? If it's descriptive, then DEFCO can certainly go ahead and file a trademark application. And they can do so by claiming that they've acquired distinctiveness because they've been using it for at least 5 years. So that may be a valuable thing for them to do. And also, if they're expanding, they should conduct a little bit of due diligence to see if they would be cleared to continue using this mark. For copyright, this is also important and tied to agreements. So expanding its services into New York and Pennsylvania, copyright or agreement, not that big of a deal, but the selling recordings, so that's going to be an issue. DJ services, what they do is normally they license in the right to perform music at their wedding events, at DEFCO's wedding events. So DEFCO needs to review the license agreement that it has in place with the licensor to make sure or to identify whether DEFCO also has the right to distribute copies of. Because even though DEFCO is creating recordings and will have copyright protection in the organization of those playlists, DEFCO may not have the right to play the music itself, because that's the right to perform as opposed to the right to make derivative works or reproduce copies of. So that's going to be a significant concern for DEFCO and something to consider before they start selling their recordings. Yeah, and there's probably more that DEFCO can do, but that's the first things that jump to mind. Then in closing, always remember, like, IP is a very important part of your business and it should be used correctly. Doing so involves due diligence, both on the asset building side as well as on the clearance side. Make sure that when you do take steps to obtain IP, that you're obtaining quality IP, because if you have bad IP protection, it's not going to give you much value and it may even make things worse. So in order to do this, you want to think about this early. You know, if IP becomes an issue, it's probably too late at that point. And don't oversimplify or ignore IP. Remember, there are things you can do yourself and certainly should do yourself, but IP is very complex and often requires experts to help you obtain the really valuable IP. So hopefully that helps. And if you have questions, I know that there's one in chat already. All right. Oh, the question is, what do I mean by legal tech companies? Do I mean LegalZoom? That may be considered a legal tech company. I don't really want to name names, but in general, it's those kind of companies that try to help you either find, template agreements, and they'll say that they'll draft an agreement for you. Like, that's a concern. Downloading a template, like, you're okay there. Like I was mentioning before, you can start from the template and revise to your needs. But any of those, if it's not a law firm or a lawyer specifically, you don't know whether there are licensed attorneys involved in that process at all. And that's where it becomes dangerous and also illegal, because it could be the unauthorized practice of law. What about Q&A? Okay, well, any more questions?
Please feel free to post in the chat or the Q&A if you have any questions.
Right. Oh, okay, we have another. What if you produced the book, the publisher?
What if you produced a book with a publisher, say 10 years ago, and at that time gave them copyrights, but now it has expired? How should I go about claiming rights?
Well, that's an interesting question because the copyright has not expired. I'm guessing your agreement with a publisher expired. Is that maybe what you mean? Because again, the copyright protection lasts for, if you are the author, your life plus 70 years. So it would seem that the publisher may continue to have rights. What you would need to do is really go through that agreement, and at this point, probably consult with an attorney, but look through the agreement to see if there's any sort of discussion about what happens to the copyright rights if the agreement between you and the publisher terminates. It's probably what you would do. So the next question, what is an algorithm or database or formula considered? That's a great question. An algorithm is a set of instructions that a computer can run to create some sort of effect. A database is just a compilation of information in whatever form. A formula, that could be, let's say, if you are creating a drink or a food, like a recipe is a great example of a formula, something like that. So it's the steps that you take or the ingredients that is necessary in a certain process or in creating a certain product, that would be considered a formula. Ooh, wow. Now we got them all coming. Okay. We have volunteers who periodically write articles for our newsletters. We have them sign a permission form that allows us to use the article. Does this permission form need to contain the words "work made for hire" when no money has exchanged hands? So to answer your question first, the money exchanging hands, that's not really a concern for work made for hire as long as there's what's known as consideration in the agreement. and consideration doesn't need to be money, it could be something else. So you have them sign a permission to allow you to use it. So as long as that permission form has the correct language that you're allowed to use it, then you can continue using the article. But it seems like your situation may lead to the volunteers owning the copyright rights to that. If you need copyright ownership, in this situation, maybe not, because you're just publishing these articles in your newsletter. You're not going to do too much more with them. But then again, further than that, you should probably talk to an attorney, really discuss why you may want ownership and what that would entail for you. So that's how to proceed with that. Okay, if I register my business for products and services, should I consider copyrighting the name of my company as well? Or is it only specific products? So neither. Copyright protects the artistic expression. So your name is a name. Maybe if you have some fancy design when using your name as a logo, that could be subject to a copyright. But copyright's only the artistic work. So it's the artistry on your marketing materials, you know, the coloring or artistry on your product packaging, whatever it is like that. Your name, if you're concerned about protecting that, that may be more amenable to trademark protection. So consider that.
Okay. We have a question here from Gisela. She says, hi, I'm opening a new online boutique and I'm creating some designs with a clothing manufacturer and was thinking to trademark my brand. I don't know if that's a good idea.
Yeah, I can't really answer that. That's certainly specific legal advice, and that's very particular to your situation. And really the answer is it depends. And I'm sorry, I can't give you more information than that. And also back to Mary Warner, we just want permission to publish. If you just want permission to publish, then make sure that the permission form expressly says that, and you should be fine. And also, thank you all for the questions, and you're all welcome. We still have 10 minutes, so keep them coming.
Yeah, we have a question from Lisa. Lisa posted in the Q&A section here. Is the USPTO the proper place to start a patent search?
Yes and no. It is where you want to start searching eventually, but you may save some time if you just start with a basic Google search, because you may find hits immediately. Using the USPTO database or even Google Patents, it takes a little bit more time to ramp up to how the searching is done and how to best conduct your searches. So you may save some time with the Google searching, but definitely if you don't find anything, just basic Google searching, then go to the USPTO and or Google Patents. Oh, I can see that.
All right, any other questions? I know someone just emailed me a question. Let's see if I can.
No, there's one. I mentioned something about language that should be in a contract if you hire a web developer to make a website for you. Can you show that page again where you were referring to that? That was slide 16, and you'll be getting a copy of all of those slides. And essentially that language is just, this work is intended to be treated as a work made for hire. Basically you're just spelling out the intention that it's a work made for hire. What is, okay, another question from Rita. What is an equation considered and what is it protected by? I am not quite sure what an equation would be considered, but it itself would not be protected by any form of IP protection. Maybe your use of it could possibly be patentable, like what the end goal or the end result of that equation, possibly, but that may not be patentable subject matter. That's something to look into. And again, the output of this equation, maybe it would be best used as a trade secret. If you're the only person that knows this equation, nobody else knows it, and it provides you value, probably trade secret's your best bet. Yeah, that's about it. Copyright, maybe, and what ends up being the output of that equation. Yeah, so one of the things in patent law for patents is patentable subject matter. And this is related to whether an invention is useful. So patentable subject matter cannot be an abstract thought or a law of nature or something like that, a natural product. These things aren't patentable. So an equation is often considered either an expression of a natural law or it could be an abstract idea. So it wouldn't be directly patent protectable, and also likely won't be protectable by the other forms of IP except maybe trade secret. Okay, Mary, when it comes to digital apps with the creation of computer code, does this fall under copyright or some other form of IP protection? You jumped in late. So now, I didn't quite cover this. I did sort of indirectly, but this is a great question. So computer code can be protected in various different ways. So the copyright aspect of protection only extends to the way the code is written. So anything that's not functional in the written code, maybe author comments or organization of certain steps in the code, if they're not functional in nature and they're not required, that might be copyrightable. The output of the computer code, if it is new, non-obvious, and patentable subject matter, that may be patentable, but also trade secret. If you don't publish that code and nobody outside of your business knows about it, that could be something to use. And then trademarks generally for your business or for the brand that goes along with the code. That's what you could use. And we have another question in the Q&A from Lisa. What is the purpose of a provisional application? So the purpose is really, it's kind of I said before, a placeholder. It's a chance for you to get your foot in the door because, as we mentioned, the way patentability is determined is whether your invention is new or non-obvious over the prior art, and it is the prior art as of the date of filing your application. So one of the purposes of a provisional application is you file, say, today, and within a year, maybe you get your stuff together to maybe other embodiments of your invention to add into the non-provisional application. Maybe during that 1 year period, you're looking for funding or you're trying to shop around to see if there's any market attraction for this, if there's any viability to it. But if you do file a non-provisional application at some point within the year, then you can use the provisional dates filing, the provisional filing date as the date of the non-provisional. So we're getting into kind of complex patent law stuff, but what this means is that if you had filed today with your provisional application and 2 months from now, somebody else files on the same exact invention, then when you file your non-provisional, you will have been to the patent office earlier than the later filed applicant. So you would get a patent potentially, whereas the person who filed 2 months after the date of the provisional would not get a patent. It would be, their invention would be rejected over yours. So that's kind of the point. It's also less fees, less filing fees involved. There's less requirements for filing a provisional application. So a provisional isn't examined for patentability or anything like that, but you need to have certain aspects of a patent in it, just a specification, drawings, if applicable, and the title and some of the filing documents. So maybe if you have some kind of bar date coming up, that could be an issue for you, and you really need to get something on paper. You file a less detailed application as a provisional application to save your date, to make sure that you don't have a bar date. Because also in patents, again, the prior art issue, if there's prior art that even you've put out there, it's your prior art, that can be a bar to your own patentability of an application that's filed more than a year after you've disclosed your invention. So that could be another purpose of filing a provisional. Like, there's reasons to file a provisional, and they're not always quite clear cut. Oh wait, there's more?
Well, I have one last question that someone emailed me and asked me to ask. The person said, I started an online fashion boutique where my logo, which is the same as my business name, is printed on clothing. Can I trademark, should I trademark my business name, the design of the logo, or the clothing on which my logo is printed on, or is all these covered in one filing? I don't know.
They wouldn't all be covered in one filing, because trademark only protects the source of those goods. So as long as whatever that design aspect is indicates to consumers that you are the company that's providing those goods, those aspects, those uses of that logo or name, that can be protected by trademark. If it's being used as like an artistic aspect that you're selling, just the art of it, that's not going to be protected by trademark. That would be protected by copyright. And real quick, Lisa, to answer your second question, where do you obtain it? So a provisional application isn't an application that you fill out like a copyright application is. It's something that gets drafted and has a certain structure, and then you file that with the patent office.
All right, so it's now 2:30. We have another webinar starting at 3. I think that would conclude today's webinar.
Okay,
So
great.
for those of you, well, I'm so sorry, Mike. Go ahead.
No, of course. I was just going to mention, if any of you have any further questions, reach out to the SBDC and they'll send you along to me, and I'll be happy to answer them.
Yes, so correct. I don't know if it's being shown on the screen, but our contact information should be there. So for those that want, you have additional questions on patents or trademarks or copyright, please feel free to reach out to the NJSBDC at Rutgers-Newark. You can send us an email at rnsbdc@business.rutgers.edu, or you can you could request a one-on-one consultation with Mike. So I did mention at the beginning of the presentation that Mike is also an SBDC consultant. So for those that want a further consultation into intellectual property, please visit our website at www.rnsbdc.com. That's RN for Rutgers-Newark, SBDC for Small Business Development Center.com. And you can complete the request for counseling form that is located in the top right-hand corner of our website. Once you complete that form out, you will be assigned, and someone will reach out to you within 24 to 48 hours. For those in the Essex County jurisdiction, you are serviced by our county. For those that are outside of Essex County, you will be referred to your local SBDC office. But just bear in mind that Mike is a SBDC consultant for statewide. So he's not just for Essex County only. So I do encourage everyone to feel free to complete that request for counseling. As I stated before, a copy of the slides will be sent out, and hopefully within the next 24 hours, I will be able to send out a copy of recording of this presentations for those who attended. So with that, I would like to thank you, Mike, for taking the time out, for giving us such a informative presentation today. And to everyone, thank you for participating, and we hope to see you on our next webinars.
Yep. Thank you.
Have a good afternoon, everyone. Bye-bye.